soon. It was Tuesday, as I said. So I stated that I sent her an email and said, I don't have an attorney. However, I don't need any continuance for this court hearing. I'm completely ready to go. I'm ready to embarrass everybody involved. Straight what I said. But yet then they're going to turn around and say I'm hostile. So me saying I'm going to embarrass these people for their lies and everything is me being hostile? You guys violating my rights isn't being hostile to me. You guys proving to the courts that parental alienation is in fact what is going on here, and you guys wanting me to undergo mental evals, drug screening, alcohol treatment, and all this shit is not being hostile to me. And all I say is I'm ready to embarrass you about it, but I'm hostile? This is your hostility here. This is how I'm being hostile, Carolyn. This is how I'm being hostile, Miles Russell, Kate Orlando, all of yous. Stephen Downing, Ephraim Benjamin, or Benjamin Ephraim, whatever the hell his name is. Those are Juliet's attorneys, Stephen Downing and Ephraim Benjamin. Miles Russell is a CPS attorney. They're allowed to abuse my rights, violate the law, forge signatures Juliet has on documents and submitted them to Mason County, and the judge allowed it to have. Judge didn't say nothing about it, didn't even check the documents or anything else. And again, his name will be being released as well in a video, but that's upcoming. Yeah, they think everybody should have to, be victimized just because they feel like it, just because they have a bias against fathers in the state. Now, the documents show the parental alienation and everything. Again, my question comes back to, why is it that these investigators, CPS investigators at that, neglect to mention it in any of the documents they submitted to the court, but instead want me to undergo all kinds of treatment when I'm the alienated parent? And the way it's supposed to work in Washington is parental alienation. I'm not supposed to be subjected to that shit. But yet here we are. Why? Because I'm the father. Welcome to my life. This will be the first of quite a bit of information that I'm going to be releasing public. And here's the kicker. The next court hearing is in May. I think it's May 26th. So yes, it's still going on. And I'm releasing this shit publicly during the middle of all this. That's the point they've pushed me to. They want to see anger. There you go. Here's my anger. I hope you enjoy. And I really do hope you attorneys find this and listen to it. Especially Miss Parker's attorneys. Because for you two, well, before I end, let me get into that. Juliet's attorney and the CPS caseworker both already guilty of perjury in this case. Straight up, literally guilty of perjury. But yet nothing's been said. CPS, I have an audio recording that I'll be getting to later, where I'm speaking to the supervisor, Carolyn's supervisor, and I tell her I have not recorded, nor will I ever record, any of the conversations between me and my child. I don't need to. I know what my child says to me. I remember what she tells me. And she's not part of the ones trying to screw me over. She's innocent in all this because she doesn't know that she was lied to by her mother all her life. She's innocent. I have no reason. Plus, I have no reason to record her anyway. That's my daughter. And that's my daughter. I ain't going to record her. That's just stupid. But anyway, I have an audio recording to the supervisor where I say this. Why is it that when they went to court, while under oath, the caseworker said, or the investigator, not the caseworker, the investigator stated that I'm recording conversations with them and my child. Now, the investigator and her supervisor both were told on video, or audio rather, that my daughter is not being recorded. But yet they run and tell the courts that. And then in the first hearing in March, Juliet's attorney, while under oath, tells the courts that due to the overwhelming evidence in 2015, the no contact order was issued between me and my daughter. Well, here's one of them things where, again, I might not be a smart individual, but usually when an order's signed and it's only got one party signature and the judge's signature on it, when the other party was involved in the case, usually indicates a default decision. However, the fact that the courts got sent notice that my attorney was fired and I'd be dealing with things on my own, and by the time I got anything back, it was that everything was already done. Basically, is what happened is my attorney at the time, Sarah Whitney, in Mason County, took over $7,000 of my money and bailed on my case. Quit working on it and everything else. For the first couple months that she had actually quit on my case, she was still emailing and such, telling me that things were just being continued and blah, blah, blah. So I really didn't know what was going on because I'm not in Washington, I'm in the state of Missouri. By the time I found out, it was too late. 2015 order was entered on through a default. Juliet knows this. Juliet is very well aware of this fact. But yet, her attorney, under oath, stated to the courts, the overwhelming evidence in 2015 is what led to the order from Mason County, Your Honor. Dude, you've been practicing law over 30 years, bro. Over 30 years. And you're going to get up there and intentionally lie thinking I can't call you out and won't call you out on it? Stephen Downing, come on, bro. Do better than this. Do better. I've already told you directly where to go for the evidence since I'm acting as my own attorney. I've already told you specifically what evidence to look for via email. Don't lie to the courts, bro. For real. You and Mr. Benjamin lie to the courts. Y'all, I'm going to call y'all out on it. I'm going to hem y'all up. I'm going to question your credentials right in front of the judge. Dead serious. I'm going to question your ethics and morals right in front of the judge as every time you lie. And please be aware, I do intend to go to the Washington State Bar Association about this with what I already have, the rest of the information y'all are going to give me and everything else. I'm already speaking with, well, a Seattle-based attorney, we'll say that, about what's going to happen on the back end of all this. And I'm also looking into a few other things in my area. So, this is going to turn out interesting. This is going to be big and blown up because, well, Juliet Parker and her criminal case is going to ensure that. So, I hope for once they finally do the right thing. Follow the law. Follow their own fucking laws. That's all I want. Because if they follow their own laws, I'm good. But no, because I'm the father, and if they don't screw the father over, they can't make the father pay child support. And if the father's not paying child support, the state loses federal monies. So when it really comes back to it, it's all an extortion racket from the state of Washington to extort parents of their hard-earned money through child support just to get federal dollars. Think I'm lying? Look into it. Look into if states get federal dollars for collecting child support. You'll see they do. And you'll see why some states have the incentive to collect as much child support as they can, and why some states are extremely biased towards one parent just to jack up child support even more. That's Washington State. Like I said, my name's Daniel Gaines. Juliet Parker's my ex-wife. A quick Google search. You'll learn enough. Mason County Courthouse, Mason County, Washington. All Parker versus Gaines. It's public information. Y'all can get all the files, all the information you want. Get the transcripts. Check out Juliet Parker's declarations alone. Every time she submitted one, completely different story. Not just little details, the whole fucking thing. But alright, that's it for this video. Next one I'll do in a few days. Y'all have a good one.